Well, hello there. Excellent for coming. Thank you for coming along. Let's see if I get this right here. All right. Making sure everything. Thank you for joining me. Just getting the video just perfectly for us here. Right about here would be fantastic. Okay, excellent. All right. We are streaming. Now, welcome to the Big Bad Baby Bar. This is a baby bar review course. And we're going to start out today, because this is the first time I've streamed for the Big Bad Baby Bar, by introducing myself. My name is Jared Harlan. I graduated from the Law School of University of Honolulu School of Law. Currently in California, they currently changed names to the Concord, or excuse me, not Concord, but the Central California School of Law. I graduated from that school in 2017. I previously took the baby bar and passed in June of 2013, and I just took the general bar given by the California bar examiners, and waiting the results. Hopefully that will have gone well. Oh, I'm just gonna check the stream real quick. This is the first time I've streamed. What?
You have to click the live button up on the thing. So that's
Okay.
preview.
I'm just previewing.
Uh-huh.
Are you seeing my preview?
I'm not seeing you at all.
Okay.
You have to go. You got to go to YouTube, and then there's remember. Then you have to click the live.
Oh, please check the video resolution. The current resolution is this, which is not optimal. Okay. So what should I do?
You have to
Lower.
lower your resolution to
Where's the resolution thing?
the edit. Okay.
I don't
No,
think
it's not
there's.
that.
That's not a problem.
I think your resolution. I think it has to be on OBS. I mean, it has to go over.
Settings.
How did you do that?
Okay. Outstream output. Okay. Your video output is correct. Please turn off any outputs to change video settings.
I think that's it. Yeah.
We're fine though. Are we saying that's not good?
It means it says your resolution is dangerously.
Which is not optimal. Please. Okay. Oh, I got you. So I can actually do a little higher.
Yep. You can go a little higher.
This is actually okay.
You're okay.
Yeah,
You're in good connection.
I'm okay with it. Yeah.
But is
So how do I go active?
did you do the live and then you clicked live?
Yeah, I'm actually live right now.
Oh, you got some lag.
Can you guys actually see me on there?
I'll check really quick.
how's the streaming though?
You're good.
Is it coming in slow? What?
No, no, it's coming in good.
Okay. All right.
You're live.
Okay. All right. Thank you so much for coming to the first year law students exam review by Jared Harlan. My name is Jared Harlan, and it's the Big Bad Baby Bar review that we are going to be talking about today. Thank you so much for uh, being with me today and this evening. We're going to look at the June 2020 essay number 2 contracts question. But before we do that, I want to tell you just a little bit about myself again, because this is the first time I'm doing this stream and I'm just setting it up so that we can enjoy it together. And so thank you so much for being patient. Well, again, my name is Jared Harlan. I took the first year Law of Students exam in 2013, and I passed in that year of June. I subsequently continued attending law school all the way up to 2017, graduated with a Juris Doctorate from University of Honolulu School of Law, located in California, Modesto, and I just took the California General Bar. So I'm awaiting results, which should be posted in December of 2020. So uh, much prayer and hope on that. Now, now on to the baby bar. The baby bar, again, is a big bad baby bar, but we can overcome that big bad baby bar. Now, we're going to look at essay number 2, the question number 2 from this most recent baby bar, June 2020. I'm already going to tell you what area of law it is. It's going to be contracts law. Okay, we're going to go through it on the Adobe Reader here, and we're also going to have on the right side our Google Documents that we're going to walk through how we would actually outline this essay. So, first thing on question number 2 that we notice is that it comes with a call to question. We're going to look at the call to question, and it says, what arguments will seller make in support of her claim? What defenses will buyer assert? And what is the likely outcome, including what remedies, if any, can seller expect if her claim succeeds? Discuss. Now, if you've read that for the very first time, you didn't know what area of law it is, you can almost automatically understand that we're dealing with civil law rather than criminal law. If we just peeked up, looking at the paragraph that came before this call, we would see that seller sued buyer for breach of contract, which is a nice way of the bar examiners of telling us what area of law we're dealing with. Not only are we dealing with civil law, we're dealing with contract civil law. And now that we understand our area of law, we can put down our shopping list, and our shopping list should begin with a general overall understanding that contracts are basically broken up into 3 particular phases: the formation phase, the performance phase, and the breach phase. Now remember, not all these are going to be treated equally on an essay. Most of the time, you're going to be spending the majority of your time on the performance and the remedy phase. But you can have those special essays, and often, and in this one, I believe we're going to be presenting one where all 3 are going to receive almost equal treatment. Okay. Now, we would first put down our applicable law. Why is that such an important thing? Well, that's because applicable law, because we're telling the bar examiners that we appreciate the fact that the area of law that directs our analysis will be included on our paper, and we put this on our shopping list. I call it a shopping list because it's some people call it an issues checklist, but I call it a shopping list because it's the same equivalency as if we were to go into shop. When we go into a grocery store to shop, we don't forget a thing on our shopping list because we put it down ahead of time. And that's what we're doing right now. We throw down our applicable law. We throw down a concept called contract formation, which we will explain as we go here. We throw down an additional aspect of third party beneficiary, if it's there. We throw down performance. Okay. We throw down discharge of duty. We throw down breach of contract, and we throw down remedies. Okay. Now, with this being said, the reason why I threw down third-party beneficiaries, I haven't read the question yet. I don't know exactly if we're dealing with a third party or we're just dealing with two parties, okay? So I just do this ahead of time to train myself to say I'm looking for a third party if a third party is there. Okay, now with this down on our shopping list ahead of time, which is actually going to be on our screen, and I will explain this a whole lot better as I get more trained in streaming, and we'll be able to explore this a little bit better as well. That your exam experience on the basically the digital exam that the California bar is administering through the baby bar through distance due to COVID has a basically a laptop requirement. So basically, well, I should say a laptop requirement. Excuse me. There are handwriting options, but the majority of applicants are going to be using the laptop option. In the laptop option, excuse me, you're going to be looking at using your screen a lot, and we're going to explore that aspect of doing your outlines on your screen, because I heard this from a great tutor, a bar tutor, that we don't want to write our essay twice. Okay, so when we're not writing our essay twice, we're writing it on our essay board. Okay, that's why we have our shopping list here. We may have to delete some things, but we may keep some things as well. Okay, now with that being said, we're going to be going right into our question. Question number 2. Seller is a merchant in the business of making fine guitars, which are sold to retailers or which was sold to retail dealers at wholesale prices through an online catalog. Buyer is a merchant who owns a retail music store that sells numerous brands of various stringed instruments. Buyer emailed seller asking that 10 Model A guitars be delivered to buyer at the wholesale price of $5,000 each, as listed in the catalog. The next day, seller emailed an invoice for $50,000, stating 1, that delivery be made within 14 days, 2, that any complaints about the condition or quality of the guitars and our return request must be made within 10 days of delivery, and 3, that payment is due on delivery. These 3 provisions are customary in the musical instrument industry. Buyer received the invoice but did not respond. The guitars were delivered to buyer 11 days later, but buyer sent no payment to seller. 2 weeks after the instruments were delivered, after having had several customers buy other guitars instead of the Model A, buyer sent an email to seller stating, "These guitars do not satisfy my customers' needs. Therefore, I am paying for them. I am not paying for them, excuse me. I am returning them at my expense." Seller sued buyer for breach of contract. Now we're again back at the call. What arguments will seller make in support of her claim? What defenses will buyer assert? And what is the likely outcome, including what remedies, if any, can seller expect if her claim succeeds? Discuss. Now, right here we've gone through one reading technique that I like to call movie mode. We've read it once for content. Why is this so important? So that nothing at the end of our question is going to trip us up concerning facts at the beginning. The reason why it's a very good kind of insurance policy to read your questions one time is exactly what we just stated. You're not going to have any surprises. Everything's going to be on your mind, fresh. And when you go back a second time, which is what I recommend in order to issue spot, you'll then have, number one, your mind will already be working on this, okay? Guaranteed. My mind is already even working on this as I went through it. I know yours is as well. And with that being said, what we're looking at here is a contracts law essay, okay? Our second read through this question now, we're going to be reading with a laser-like focus. We're going to be zooming in on these facts to find issues. Now, did we have a third party? Let's ask ourselves this. Did we have a third party? No. So we can actually get rid of our third party beneficiary right off the bat here, okay? But we have to start filling out as we're reading too our 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 outline, okay? Why is this important as we're issue spotting? Oh, yes, I can see you typing. I can definitely see you typing. Can do you how is the broadcast so far? Huh. I wonder why I can't you guys can't type to me on the live chat. Let me look that up. Huh. I'm not sure why that is. Okay. I actually I've enabled allow chat to replay. We've enabled live chat. It's there. It should be there. Hmm. Okay. All right. I won't worry. Okay. Now, as we're working through question two, seller, we understand because the facts tell us that seller is a merchant. What is that? What is that going to mean? Seller being a merchant indicates to us that seller is a someone who is held to a higher standard of good faith and fair dealing. Now, does that mean automatically that we're dealing with someone, or are we dealing with the area of law called the Uniform Commercial Code? Probably not yet. We don't have a full enough understanding. So let's continue. Now, seller is a merchant in the business of making fine guitars, which are sold to retail dealers at wholesale prices through an online catalog. Buyer is a merchant who owns a retail music store that sells numerous brands of various string guitars. Within the first paragraph now, we understand that both parties are merchants, but again, still we haven't quite gotten to the bottom of what our governing law is. Buyer emailed seller asking that 10 Model A guitars be delivered to buyer at the wholesale price of $5,000 each as listed in the catalog. This is where we've hit pay dirt. Under applicable law now, we can say that we're dealing with the Uniform Commercial Code or the UCC because we're dealing with a good. And a good, what is our good here? Our good, and I'm just going to switch over here to a highlighter. I'm going to change color from that to yellow. Okay. Okay, we're going to switch over to a highlighter. Buyer emailed seller asking that 10 Model A guitars be delivered to buyer at the wholesale price. So we're talking about Model A guitars. Model A guitars. Oh, let me undo that. I'm going to get a better color. Thanks for staying with me. Okay, we'll try. Let's see here. We'll try that one. Okay. 10 Model A guitars. The Model A guitar here is a good. Therefore, we have the Uniform Commercial Code governing our transaction. At this point now, we can start filling out with additional detail. If you are so inclined, we can actually put in merchants now because we have identified that both parties, seller and buyer, are merchants. Okay. Why? Now I should go back up here and establish what does the Uniform Commercial Code govern? It governs the sale or transaction in goods. Goods, by definition, under the Uniform Commercial Code, are tangible personal property, okay? And they're identifiable at the time of the contracting, okay? What does this mean? That the Model A guitars are movable, they're tangible, therefore they're goods. And therefore, because this is a contract concerning goods, the Uniform Commercial Code would govern this contract. First step, we have our applicable law tackled. Number two, merchants. We just said in paragraph 1, seller and buyer are merchants, and thus seller and buyer, because they are merchants. Now we have to establish what merchant status is. Merchant status is those parties who regularly deal in the goods of the kind or who hold themselves out as having special knowledge or skill related to said goods. And those parties, seller and buyer here, most likely are merchants of guitars. And since we're dealing with a contract concerning guitars, they would qualify as a merchant. Okay, and as a merchant, they're held to a higher standard of what we call good faith and fair dealing. Now, after this, we're going to be going down and seeing something very unique. At this point, we don't want to lose something very important up here. Okay, we come down and we see something called a catalog, okay? Right here. Okay, so buyer emailed seller asking that 10 Model A guitars be delivered. Excuse me. Let me try this again here. Okay, the catalog that we're talking about, okay, is something called a preliminary negotiation. But I should, before I get going there, I need to take the time to establish what are the elements that make up a contract. A contract is made up of both an offer, an acceptance, considerations, and any defenses that may work against enforcement. Primarily the statute of frauds. So we're going to throw in statute of frauds here. And don't forget about that, any particular defenses at that. So we'll just throw in defenses if that is applicable. Now, looking at offer, we have to establish what an offer is under the Uniform Commercial Code. An offer is an intent to be bound to certain definite terms communicated to an offeree. Could we see here that buyer emailing seller asking that 10 Model A guitars be delivered to buyer at the wholesale price of $5,000 each as listed in the catalog be considered an offer? I think we could. I think we have a very good chance of having that be an offer. Why? Because number one, we have intent to be bound. Did buyer's email to seller indicate buyer's intent to be bound to an offer? You might be asking yourself, wait a minute here. This email, isn't this in a response, or is this the actual offer itself? Very good question. This is actually an offer itself, okay? Because remember we were talking about preliminary negotiations. This is where you'd plug that in. I'm going to throw that in right now, so we don't forget preliminary negotiations. Well, now what would that pertain to? The preliminary negotiations. You would be surprised. It would be the catalog. Why? Because if we come up here and we look through an online catalog right here, we found that seller's merchant status in the business of making fine guitars, which are sold to retail dealers at wholesale prices through an online catalog. An online catalog, in essence, is an advertisement. Remember, you don't really have enough facts to go on here. So as an advertisement, generally an advertisement is not considered an offer, more of an invitation to bid or an invitation to make an offer. And that is exactly what buyer did by emailing seller. He made that offer. And when he made that offer, we now have to look to whether or not that offer represented intent by buyer to be bound, which is exactly what he did by emailing seller asking that 10 Model A guitars be delivered to buyer at the wholesale price of $5,000 each as listed in the catalog. So essentially what buyer is doing is borrowing in essence, and it's essentially borrowing seller's terms in the online catalog and saying, I want those terms to represent my offer to you. Okay. And now we're going to look, not only do we have intent, we come down here and we have intent, but we're going to look to terms now. Terms. The terms of our contract under the Uniform Commercial Code are a little more liberally interpreted. There's only one particular term that has to be there and has to be there certain indefinitely, and that would be the quantity term. Okay? The Uniform Commercial Code stresses quantity very hard. Okay? But the other terms can be filled in with reasonableness and potentially other forms of reasonable interpretation. Now, under terms, though, we're looking to see if we have the four primary term, the four primary terms that are pop up in an offer are quantity, time, interested parties, and price, and don't forget subject matter. Now, like we said, quantity definitely reigns supreme. Quantity is chief, okay, in the Uniform Commercial Code. But how many? Okay, you can read through here because you've read this with me. How many is buyer's offer obligating? I'm sorry, excuse me. Buyer's offer to seller. How many quantity of Model A guitars is buyer obligating himself to? Exactly, 10. So we have 10 Model A guitars. Okay, the time here, since we were not really sure as to what time the delivery is to be made, we probably would say a reasonable time. Okay, because remember, Uniform Commercial Code can fill in missing terms with reasonable interpretation. This is one of those instances. So we could say reasonable time. Now, interested parties, which is a nice way of saying the contracting parties. This would be buyer and seller. Let me get this for you here. Okay. And now price, I was going to come up here and shorten this up here. Buyer and seller. Okay, great. Okay, now price. What was the price that buyer made his offer to seller for each of those Model A guitars? $5,000. Exactly right. You saw that. Excellent job. Subject matter now. I think you already know that one. We've talked about that a lot. Model A guitars. Okay. Now that we've established the terms, has this been communicated to our offeree? And you might be asking, well, who's an offeree? Well, the offeree would be seller here. The offeror, the offeror, the one who's making the offer would be buyer. The offeree, the seller, would be the one that the offeror, buyer, would have to communicate to. Do you think that the buyer's email communication to seller, I'm already giving it away here a little bit, buyer's email communication to seller would be communicating to seller? You're smart, absolutely correct. So we have all three requirements for offer right here and right now. So we have buyer making a valid offer. Excellent job. Excellent job. Now, remember, sometimes you have to copy and paste. I probably should copy and paste this up top with the preliminary negotiation. We'll cut this here. We'll come up here and we'll put this before. Well, actually, we might. Yeah, we'll put this before offer here. And okay. I should say, you know what? I'll just type this in already. Preliminary negotiation. Okay. Yeah, preliminary negotiations. That would pertain, I think, where I talked about this, the catalog. Okay. Why? Because we're addressing the fact that we're dealing with an ad that's generally not considered an offer. But again, back at the ranch here, is buyer's offer the valid offer? Absolutely. So now we got to ask ourselves here, as we further read, was there an acceptance? Because technically, by definition, an offer plus an acceptance equals what we call an agreement or a contract. Okay, now, with that being said, let's continue reading. The next day, seller emailed an invoice for $50,000 stating what? One, that delivery would be made within 14 days. Two, that any complaints about the condition or quality of the guitars and our return request must be made within 10 days of delivery. And three, that payment is due on delivery. These three provisions are customary in the musical instrument industry. You might be asking yourself, what's the deal with the 1, 2, and 3? Those are added provisions. Now, you might be asking, added in what way? Well, under the Uniform Commercial Code, when during the acceptance stage, there is a time at which parties can negotiate terms, okay? Even though there's an offer being made by buyer, that does not mean that seller has to accept those terms. Seller has his or her voice in the matter, and they can change terms and negotiate terms, which is exactly what's going on right here. Seller emailed an invoice. Now remember, we have to keep this premier in our mind. We're dealing with two merchants here, okay? Why is that such a big deal? Because the Uniform Commercial Code has a special term when merchants are essentially battling terms back and forth at each other, negotiating what will ultimately become the their contract. Okay, and that legal term that the Uniform Commercial Code supplies is called Battle of the Forms. Now, you might be asking yourself here too, are these additional terms or are these different terms? Well, these would be additional terms. Why would you say they are additional terms rather than different terms? Well, because a different term is one that the buyer, or sorry, I should say it's going to be the offeree would change in some way. It existed from the offer, and in the acceptance stage, it changed somewhat in maybe in a term, or in a quantity, or in a price, or some form or fashion. And essentially it's conflicting those two terms. Now, the one that's being sent by our merchants, the the one that is in conflict is a different term than the one that was originally sent in the offer. We don't have that here. So we have what they call as an additional term. In the a different or additional or different term is sometimes what is called, even though the different term aspect is something we're gonna talk about under conflicting terms, which is what we just talked about. So back at the additional term, because we don't have a different term, we have an additional term. And with that, we have battle of the forms because we have both parties are merchants, okay? And we want to make sure to supply our UCC code, which is a nice way of sounding smart. And we are smart, so we want to sound as smart as we can to our bar readers who pretty much do our evaluation of our papers. When we do battle the forms, we want to make sure to supply our UCC code 2-207, which is exactly what we're going to be pertaining to or addressing, and what this contract pertains to, because we're dealing where both parties are merchants. Now you might be saying, do both parties always have to be merchants? No, you can have one party be a merchant, the other party be a non-merchant, but the outcome here would change different, or would change slightly. The proposal, or I should say that the offer made by the merchant to the non-merchant would be considered a proposal. Now, you might be asking yourself here, what essentially happens to these three terms then when we're dealing with two merchants? Well, we go through in the Uniform Commercial Code, the Battle of Forms 2-207, those terms become part of the agreement unless, number one, the offer, which would be buyer's emailed expression or communication to seller, expressly excludes any additional terms. That's the first way, which it doesn't look like we have here, so we can eliminate that from our mind. Number two, do we have any terms that would materially alter the agreement as it currently stands? We're going to look at that here in a minute. And number three, has the other party, offeror or buyer, objected to within a reasonable time? Now, looking here, we at the last part of the third paragraph, we have an answer to possibly that third question. Buyer received the invoice but did not respond. Now you might be asking yourself, wait a minute here, what does that mean? That means that buyer didn't voice his objection to these additional terms becoming part of the agreement. And remember, again, I stress this over and over again, between merchants, those terms become part of the agreement, okay? And because they're part of the agreement, they embody what they call as the contract, and they have to abide in good faith and fair dealing by that contract. That's why it's so important that we talk about in detail, in sometimes minute detail, the Uniform Commercial Code 2-207. Okay. Now the first thing, again, we've already eliminated is that we don't have a firm offer here. Okay. We don't have an offer that expressly excludes any additional terms. Number two, do we have is the delivery date the delivery date being made within 14 days? Does that materially alter our contract? There's a lot of you might say argument back and forth on that, but I would have to say no. That number two, that any complaints about the condition or quality of the guitars and our return request must be made within 10 days of delivery. Now, there is an argument to be made about whether or not that affects the other party buyers remedies here. That could possibly be a material alteration. We're not really sure. Now, the third is that payment is due on delivery. Does that materially alter? Arguments can be made back and forth on that. But remember, keep in mind when we're establishing material alteration of a contract, we're looking at all of our question here. These three provisions, the three we just talked about, are provisions that are customary in the musical instrument industry. We will take this into consideration when we determine materiality of those terms. Because if they're customary in the musical industry, which would most likely be seller's argument against buyer, if buyer so chooses to take a stand and say that one of these three or more provisions materially alters the agreement, that seller could say to buyer, these terms, these provisions are provisions that we share in the musical industry. And as you know, as a merchant in the musical industry, that these are part of what would customarily represent an agreement. Now, with that being said, we could say that these three terms come in. Now, down here though, you might be asking yourself, do we still address the fact that buyer received the invoice but did not respond? Absolutely. We plug that in there as a third factor, that buyer did not respond to the additional terms. Okay. In other words, buyer didn't object to the additional terms, is what the Uniform Commercial Code says, within a reasonable time. And that being said, seller could argue that these three additional terms, the additional provisions, become part of the agreement because both parties are merchants. Now, reading onward now, we have the guitars were delivered to buyer 11 days later, but buyer sent no payment to seller. Now, you might be asking yourself, what is that? Well, under the Uniform Commercial Code, when a shipment is made, the shipment could indeed represent an acceptance. Now, you might be asking yourself, could the Battle of the Forms UCC 2-207, the aspect about seller emailing an invoice represent an acceptance? It very well could as well. But even if that weren't a strong enough acceptance, the fact that seller delivered the Model A guitars to buyer 11 days later, the shipment itself would represent the acceptance as well. So we're going to record that in our outline. Acceptance by shipment. Now you might be asking yourself, are these conforming shipments or non-conforming shipments? And what does the word conformity mean? Conformity means it's exactly what you and the offeree intended to be, the goods to be shipped back and forth. Let me rephrase that because it needs to be clearly defined. Now, a a conforming good is or a conforming shipment is a good that adheres to the contract. Okay, and what does that mean to adhere to the contract? It's in our situation, it's indeed Model A guitars. It's not Model B guitars or Model C guitars. These are Model A guitars. Okay, if there's such thing as Model B and Model C. Now, with that being said, we could say that the shipment of this was also conforming because the guitars were delivered. We don't have to take that much time. We just say that the shipment itself could very well represent a mutual assent, a form of meeting in the minds because of the fact that seller shipped the conforming goods to buyer. Okay, now 11 days later, let's just check real quick. Does that 11 days later violate any of our provisions? Well, let's take a look here. Delivery be made within 14 days. Nope, everything checks out just fine. Now, the next thing we're going to look at is the next sentence. 2 weeks after the instruments were delivered, after having had several customers buy other guitars instead of Model A, and let me stop right here, because if this ever happens to me every so time or every so often, I'll skip over a fact. If this happens to you, absolutely forgive yourself and move. You could pause right there and go back up to the fact that you might have overlooked. And in my case, I apologize. I overlooked the fact that buyer made no payment to seller. Now you might be asking yourself, what does this mean? Well, this would probably create insecurity in the seller. But before we do that, because the area of contract law is so formal, okay, and it's so systematic and methodical, we have to go through some certain steps, okay. And the other steps we have to go through at this point is something called consideration. And do we have consideration? In other words, is there a bargained for exchange between buyer and seller? And a nice way of saying that is, has something of value been exchanged for something of value? Has buyer exchanged money for guitars? And has seller, in essence, obligated him or herself to the guitar to the 10 guitars for the $50,000? And that's what we're going to look at here. And absolutely, that is the case. Do we have sufficient consideration? Now, the two elements that we take a look at in consideration, if they're present, is the bargain for exchange. Are we dealing with a gift? Are we dealing with past consideration? Are we dealing with a sham or nominal consideration? Are we dealing with moral consideration? Or are we dealing with the great pre-existing duty aspect? No, and no to any one of those. And we also ask ourselves, is there indeed legal detriment? Absolutely, there's legal detriment. Buyer is obligating themselves to paying $50,000 for 10 Model A guitars. Seller is obligating him or herself for supplying those 10 Model A guitars for in return the $50,000. So there is sufficient consideration. And as just a footnote to our discussion here, keep an eye out too for promissory estoppel. This wouldn't be the case here, but that would also be a substitute for consideration if consideration were not present. Now, so there is sufficient consideration here. I'll put a yes by that. Statute of frauds. Now, remember, the statute of frauds is indeed what it pretty much indicates. It prevents fraud from interfering with an otherwise enforceable contract. How does it do this? Well, it does this it does this through requiring that contracts be in writing, certain contracts be in writing, and certain contracts be signed by the party to be charged or the party being sued. Now, these certain contracts concern marriages, or concerning contracts for marriage, contracts that by their terms cannot be completed within 1 year, contracts for the sale of an interest in land, contracts concerning executorship situations, contracts concerning goods for the sale of $500 or more. Important part, or more. Now, the next one is contracts concerning suretyships, which is suretyship, nice way of saying, is obligating yourself to pay for the debt of another. Okay, we don't have anything but a sale of a good here. Now, do we have the sale of goods that embody more than $500 or more? Absolutely. Or I should say, is the sale of our goods more than $500 or more? Absolutely. Why? How much are they exactly? $50,000. That's exactly meeting this and surpassing it. So we have the sale. We definitely have one of the required contracts that has to be in writing and has to be signed by the party to be charged, and that is the sale of goods $500 or more. And what does it have to be in? What does our agreement have to be in? In writing. Now, the writing requirement could very well have been satisfied by the emails, and I would say that that would be a solid yes on that one. Number two, who is the party that was being charged here? Who is the party being sued? Looking at the last paragraph, like we did, seller sued buyer for breach of contract. Buyer is the one being sued. Has buyer signed the contract at any place here? It doesn't look like that. However, the signature requirement could be satisfied by the fact that buyer emailed seller, and indeed, if buyer emailed seller on one of his or her form letters, essentially a form letter representing their business letter transaction between another business, that would also indicate a signature, or that would also represent a signature, and suffice for a signature. And even if that were not even present, the fact that he or she has an email address would also suffice for a signature in our digital world that we're living in, because the UCC is indeed keeping up with the times, and it does recognize that email addresses can indeed represent signatures when those emails pretty much identify or they signify that party's identification. And in this party is a merchant. Buyer could be identified by their email address. So is there a signature of our buyer here through their emailing seller? Absolutely, very possible. So is the statute of frauds $500 or more satisfied? Absolutely, yes. But even if let's say we were not able to satisfy the statute of frauds, sale of goods $500 or more, do we have a workaround? In other words, do we have an exception? And that is exactly the case here. We have what they call in the Uniform Commercial Code a merchant's confirming memorandum. And a merchant's confirming memorandum, or confirmatory memorandum, some people say, what it essentially does is it is a communication between merchants that number one has to be between merchants. Number two has to contain all the necessary terms, which is, the return email invoice could very well have been an embodiment of those terms, plus the additional terms that ended up becoming part of the contract, which one day after buyer emailed seller, I should say, that seller emailed a return invoice. That return invoice could very well represent our merchant's confirmatory memorandum, being that it's between two merchants, that it contained all of our necessary terms, and again, it wasn't objected to within a reasonable time or 10-day period. Again, relying on that fact that buyer received the invoice but did not respond. Now, with that being said, do we even if the statute of fraud, sale of goods $500 or more, were to fail for lack of a signature of the party to be charged, would we have a statute of frauds exception that would satisfy the statute of frauds, sale of goods $500 or more contract? Absolutely. Merchant's confirmatory memorandum does indeed accomplish that task, and we have that present here. Now, do we have any other defenses? Now, there's one other defense here that we could possibly raise, and we're going to look at this in the next sentence. 2 weeks after the instruments were delivered, after it had several customers buy other guitars instead of the Model A, buyer sent an email to seller stating, "These guitars do not satisfy my customers' needs. Therefore, I am not paying for them. I am returning them at my expense." At my expense. Now, buyer is saying here 2 weeks. Now, 2 weeks is a very important thing, because we're looking here. Let me highlight this for you here. Is 2 weeks. Okay, now the delivery was made within 14 days. We know that because of the 10 days in our question. But the 2 weeks, does that violate any of our provisions? Well, yes, it does. Actually, right here, that the any complaints about the condition or quality of the guitars in our return request must be made within 10 days of delivery. There's the the complaint about the Model A is not selling, which was exactly 2 weeks after the instruments were delivered. Now you might be asking yourself, what does this mean? Well, it's 4 days after the 10-day period. You might want to raise an unconscionability argument, which unconscionability from the buyer's perspective is saying that in the conscience of the court, the court's conscience would be shocked for the lack of 4 days that the whole contract is going to basically fall through and buyers going to be left with an expense basically for 4 days. Just for a fact that seller is not willing to wait for a possible for additional 4 days. That is a very possible argument. Do I think that the defense may work? Well, it might. It depends on how well you argue those facts. Now, moving on from our defenses, the defense of unconscionability, we work now down to performance. Now, remember something too, that just because we've gotten through all of what would embody formation, we're not done yet. We actually have to go through a phase called performance. Performance is a very important time in the contract because this is exactly where most parties decide to either back out or something goes wrong and they want to change terms or some kind of unforeseen circumstance develops. Okay. Now in this instance, we have an unforeseen circumstance. Parties not buying our Model A guitars. If I were buyer, I'd be like, yeah, this is what I intended to buy. This is what I intended when I contracted with seller for the Model A guitars, that they would sell right off my shelf, my store shelf. But they're not doing that. Now, we got to ask ourselves here, is there indeed a condition, and we'll explain here, I'll type in condition for you. Is there indeed a condition that seller could say comes between his performance, okay, and buyer's duty. Now here's the thing though, I should say, let me reverse that. That buyer is going to say that's becoming between his performance of having to pay $50,000 and seller's duty, seller is going to say that he actually fulfilled his duty in actually delivering the Model A guitars. So seller is going to say, I have satisfied my end of the bargain, my end of the agreement. There's a condition that hasn't been satisfied, or maybe could be excused for buyer you not coming up with the $50,000 or returning or providing the $50,000 to me, seller. Now, a condition by definition is an event which is not certain to occur, but which must occur for a duty to perform to mature. Now, the aspect about a condition, there are technically two types of conditions: expressed and constructive. Okay, we have an expressed condition here? It doesn't really look like we have an expressed condition here. We may have a constructive condition here, and there's two kinds of constructive conditions: implied constructive conditions and legal. Okay, it looks to me though what we have here, just cutting through all of our steps of analysis, we have what they call as a condition precedent. And a condition precedent, which is our constructive condition implied is an aspect that states of concerning a condition that one party has to perform for the other party to perform, or if one party has to complete performance for the other party's duty to perform to mature. Now, seller is going to say that they, through shipment of the guitars, has satisfied their condition precedent. In order for buyer's duty, that, which is what seller is going to say, that buyer's duty now has matured to pay seller the $50,000. Now, seller has a whole, you might say, tool belt of excuses and possible arguments at their disposal. Okay, we're going to look at a couple of them here. They're going to say excuses. We're going to look at has there been substantial performance? Okay, has there been a waiver? Has there been anticipatory repudiation? Has there been any form of prevention? Is our contract divisible? Is it impossible for them to perform? Is there any voluntary disablement? And is there any estoppel? Now, we ask ourselves here, can buyer entertain any of these excuses? And I would point you to the fact that when buyer did not respond, he or she did not respond because, or excuse me, let me rephrase that. When buyer emailed back to seller stating that he would not pay for the guitars, did that not paying for the guitars represent what we call as anticipatory repudiation? Well, that's exactly what we would probably classify it as. Now, an anticipatory repudiation is a communication from one of the parties that they will not perform as contractually obligated before the time of performance is due. Now, what seller is saying is that because these guitars do not satisfy their need, they should be technically excused from not having to pay. Having to pay what? Having to pay the $50,000. You might be asking yourself here, wait a minute here, is that exactly a correct analysis? Absolutely good observation. It's not buyer saying this, it's actually seller. Great catch on that. Seller is actually going to say this about buyer. Buyer is saying, the seller is going to say about buyer that buyer's communication represented in a communication that buyer will not perform as agreed before time of performance is due. And as such, seller has a right now to consider the contract as terminated, suspend their performance, and bring suit immediately. And that's exactly what we're going to look at here. We're going to take this. Well, here's what we're going to say. Let me put this like this, because see, this is going to be seller's argument. I'll put this here for you so you can see the seller's argument. Okay, and this is the discharge of duty. Before I get too far ahead of myself, because see, remember, even in a courtroom, there's two tables in that courtroom. We have to entertain both parties' perspective, both seller's perspective and buyer's perspective. The discharge of our duty, the discharge of what? The discharge of the duty to perform has a multitude of different arguments that we're going to look at right now, but mainly three. Has there been impossibility? In other words, is buyer going to try to say that it's objectively impossible for him or her to perform? The other one is, which is probably going to be the most likely, is financial impracticability. Which is exactly, I'm so happy that you pointed this out and brought this to your attention. This is exactly what buyer was indicating when they said these guitars didn't satisfy their customers' needs and therefore they're not going to pay for them, and that they are indeed returning them at their own expense. Why are they saying that? Financial impracticability is saying that the party, what they're saying is that buyer is telling seller, if you force me to perform, which is pay you the $50,000, you're forcing me to become technically insolvent. I'm becoming this whole contract, the very contractual purpose for which we came together is impractical, financially impractical, because as being impractical, it would be futile essentially. And let me change that word here, not futile, but it would be feasible for me, buyer, to continue to perform. Now, in the agreement. Now you might ask yourself, can buyer actually say that? Can he actually say to seller, hey, because this is financially impractical, can they get out from under the contract? Well, not necessarily, because remember, when buyer entered in, buyer assumed a risk. That risk that buyer assumed was indeed that the Model A's may not sell. So even though buyer may have an argument that things aren't selling, things aren't going as they are, as buyer intended them to go. So in other words, they're not flying off the shelf. The buyer can't get out from under the contract and say just because of that impracticability has kept him or her from or has discharged their duty to continue performance, which would be supplying seller the $50,000 contract price. So would impossibility work for buyer? No. Would financial impracticability work for buyer? No. And that's due to this thing as here as we just explained, that buyer assumed this risk. Okay. Now, objectively impossible. Sorry about going too far or a little too fast on that one. The objective impossibility is that it's not objectively impossible to sell the guitars, because look at here, according to our facts, it's just because Model A's aren't being bought by buyers right now, customers of the guitars right now. The customers are actually are buying other guitars. So it's not like guitars are no longer being sold. It's that those Model A guitars are not being sought after by customers, but that trend could very well return. So it's not objectively impossible for buyer to sell these. Now, is it financially impractical practical for them to no to for is it financially impractical for them to be able to discharge their duty? No. Now, last one here is frustration of purpose. Now, in frustration of purpose, buyer is going to say that the purpose, the very essence, the very core of what the bargain represented has been frustrated. And has been frustrated by an unforeseen circumstance. Now let me ask you, if you were in seller's position, you would not want to see this from buyer's perspective, obviously, because you want to get the $50,000. But buyer is going to say the purpose for contracting, the very fact that these things aren't going to sell right off my store shelf, is the very purpose for which I contract with you seller. And therefore, because that didn't happen, my purpose for contract has been frustrated. But has it been frustrated beyond any kind of repair? In other words, has the essence, the core reason why the buyer or seller contracted with the other party, has that been frustrated? Really? Not really. See how buyer's argument is pretty weak. Seller's argument is exactly what we're saying is, buyer, even though you may have intended that these Model A guitars just fly off your shelf, they indeed, the core essence, they indeed embodied what we originally agreed. I shipped you the Model A guitars at the 10 that you requested, and as per our agreement, I fulfilled that. Why haven't you fulfilled your agreement in getting me back the $50,000 of contract price? Now, so frustration of purpose would probably fail. Now, does this supply buyer with enough arguments for saying that we have addressed discharge of the duty? Absolutely. But look at these. We have three of them: impossibility, financial impracticability, and frustration of purpose. Neither of these is going to work. Excuse me. Now, breach of contract. Now that all excuses have been entertained, all discharge of duty arguments have been discussed, we have an anticipatory repudiation in play, which means seller can bring suit immediately. We have a breach of contract situation on our hands. Now we have to ask ourselves here, again, back at what area of law we're dealing with, because each area of law deals with breach of contract slightly differently. Under the Uniform Commercial Code, we deal with something called perfect tender rule. if had this been a common law, we probably would have dealt with substantial performance. But we are not under common law, we're under Uniform Commercial Code, the UCC. So our perfect tender rule would apply. And would also would still apply because we're not dealing with a divisible contract or an installment contract at that. I should say an installment contract. Because what we're dealing with what is called as a one-shot delivery. A one-shot delivery is one delivery. That represented the whole shipment. And that's exactly what buyer received from seller when the guitars were all delivered 11 days later. Now, the perfect tender rule, did buyer can seller say that buyer perfectly tendered? Absolutely not, because buyer did not supply the $50,000. Not only did buyer send no payment to seller after the delivery of the receipt of the goods, but we also have, oh, and that, I need to make a note of this, that buyer sent no payment to seller. This could be seen up here. This could raise a very small argument here as to waiver. It's very small, that the fact that that seller didn't do anything in terms of anticipatory repudiation at that point could be seen as a waiver. I'm gonna bring this up here, right here. Grab this here for you. Okay. Okay. Now I'll delete this right here for you. Bring this up. Now, why is it seen possibly as a waiver? Because seller did not do anything when they received information that that they did not receive a payment from seller. Or excuse me, the seller didn't receive a payment from buyer. Why is that important? Well, one of our provisions that payments are due on delivery. Well, the fact that seller did not make payment on delivery could very well have indicated that seller was waiving that provision. Okay, so that was technically what we could argue as to that particular provision. There was a waiver. A waiver means that something that could have represented anticipatory repudiation or some kind of act representing a breach of contract was waived by one of the parties, and that was exactly what seller did here. Okay, now moving on, because down to perfect tender rule, can seller say that buyer perfectly tendered? Absolutely not. Like we said, buyer did not get the $50,000 to seller the contract price, and now what they're saying, what seller would say here is that not only did buyer wait too long, but that buyer is telling seller that they're not going to pay for them. They're not going to pay for the guitars. So we do not have buyer perfectly tendering here. And do we have material breach? Absolutely. Now, material is in contrast to something called a minor breach. A material breach is where the greater majority of the contract has been breached, and some people call it a total or material breach, and therefore the whole total contract price can be sought in remedies. And on top of that, the party who's bringing the claim, breach of contract claim, can indeed suspend their performance. Otherwise, in a minor breach, the other party should continue to perform until bringing the breach of contract action, and they might even have to continue performing even after that. Now, material breach. Now, remedies. This is where we're going to look into the Uniform Commercial Code for advice on how to deal with remedies. Now, remember, the first thing that we have to understand under remedies is that there's a duty to mitigate. Duty to mitigate. Mitigate what? Mitigate damages. And that would mean that buyer, or I should say the seller, the one bringing suit, has a duty to mitigate their losses so that, in essence, there's not a windfall, a remedy that greatly favors seller. Okay, so what sellers should do in essence is try to mitigate their damages in some way. We're not quite sure here exactly what that would be, but they should pursue such actions in order to make sure that the damages are have been mitigated as reasonable as possible. Now down under what we have under expectation. Now we need to look here under three particular kinds of remedies: expectation damages, consequential damages, and we want to throw in, like we did with the 2-207, some excellent legal talk, and that is we want to throw in a case here. We want to do Hadley versus Baxendale. Okay, and Hadley versus Baxendale, that deals with consequential damages. Then we're going to go down here under incidental damages. Okay. Nope. Let's try my spelling here. All right, incidental damages. Now, under expectation damages, what seller is going to try to achieve here is what the seller intended to receive as a profit from the contract, essentially the $50,000, which is be the what expectation damages coins as the benefit of the bargain. Okay, they're going to receive that. Now this is the remedy as if the whole contract were perfectly performed by buyer, which would then require buyer to perform the $50,000, which under expectation would then be a court order remedy that buyer pays seller the $50,000 contract price. Now, now going down and further arguing, because under remedies we want to make sure we argue every particular remedy that we can. Consequential damages are Hadley versus Baxendale, or Hadley versus Baxendale situation, says that consequential damages that are a consequence of the breach of contract are recoverable if they are foreseeable at the time of contract formation, and number two, they are reasonable in value. Okay, now we're looking here. They definitely $50,000 would be reasonable in value, but we don't really have a consequential damage of any kind. Now, if seller could say that due to the not being able to sell, oh, excuse me, here I made a goof here. The sellers ordinarily are not entitled to consequential damages. This would be reserved for buyer, but since buyer is not the one suing, it's only seller. This would not be available to seller. Or sorry, to buyer. It would only be available to buyer, not seller. So buyer would have to receive the expectation damages from what we talked about, and replacing what we just talked about in terms of consequential damages, we would say lost volume seller. Now we're going to ask ourselves here, what is it that seller is going for under lost volume seller? Under lost volume seller, seller is going to say that their production of fine guitars is pretty much unlimited. Number two, that they could have made a second sale, but for the fact that buyer did not, a second sale concerning what? Those 10 guitars, and that but for buyer not paying them the $50,000 and delaying so long that they could have indeed made that second sale. And a buyer could make such an argument. What they would essentially say there is that they'd be able to sell again those 10 Model A fine guitars for the $50,000 contract price. Now, under incidental damages, seller might be able to recover the cost of returning incidental damages are those damages that are a cost, expense, or storage cost of some kind as a result of mitigating the damages. If seller can say that in some way in their mitigating the damages they incurred an expense, they may be able to recover that also from buyer. Now we want to make sure at the end of our essay here that we throw in a conclusion header, because in a conclusion header we're going to sum up all of this. Okay, now we're going to cut back in later lessons as I get better at production and getting the material to you. we're going to come back and be able to do this even greater magnitude. Okay, and so hang in there. We're going to the big bad baby bar battles are going to improve and they're going to intensify, and you are going to succeed. I almost can guarantee it. Almost. This is a very tough exam, and those that go prepared definitely stand a good chance in the battlefield. But I hope and pray that you do well, and I know that you will. I am almost guaranteed of that. Now, because I know that you're listening to this channel and that you are battle tough and battle hardened. Now, and we've been going through this essay together here, and I will probably have to tell you adieu and say goodbye. But I thank you so much for stopping by, and I thank you so much for tuning in to the Big Bad Baby Bar review. And we're going to be going through another essay, probably most likely tomorrow, Lord willing, and we'll continue in contact then. I thank you so much for listening. I hope you had as much time, as much fun going through this second essay of the first year law students exam, June 2020, essay number 2, as I did, showing it to you. Thank you so much for bearing with me and learning along with me here. Excellent time together. Again, best of lucks on the first year law students exam. See you then.